Hi, welcome to the second edition of What a Thought. I do believe a moderate illness gives you enough time to think, and today we're going to talk about how, after the Supreme Court clearly declares a law or a provision of a law to be unconstitutional, it still gets enforced in the country. For some reason, I can't stop thinking about it, and it led me to read up a little bit more and try to figure out the reasons behind it. And right at the very beginning, I must start with an English phrase that says, "The truth is often stranger than fiction," and that, I think, appropriately explains what we're going to talk about. We will first talk about a broad context of the Section 66A matter, just to set the setting right. We will then talk about provisions apart from Section 66A which have been decriminalized or have been declared unconstitutional by the Supreme Court and still continue to be a matter of discussion. And then we will discuss how can a Supreme Court judgment still go unimplemented, and what can we do to sort of make sure it does not happen. And this is a major flaw in our entire constitutional ecosystem. So let's begin. I'm fairly sure all of you are aware of the context of Section 66A. You can read a consolidated article I'd written about it on the website. I'll link it in the description box below. But let's talk. See, the Information Technology Act of 2000 was passed in the year 2000, and that should give you a lot of context. 2000 is the year when social media was a rarity. Mobile phones were a rarity. So the law itself was made in a very touch and a go fashion. It wasn't detailed, it wasn't intricate, it wasn't catering to what technology would become in the years to come. And that's exactly what happened. In 2008, about 8 years after the law was passed, I think on December 22nd and 23rd of 2008, the Lok Sabha and the Rajya Sabha passed the amendment to the Information Technology Act, called the IT Amendment Act of 2008. This amendment was passed by both the houses within a day of each other, without a lot of discussion and deliberation, which seems to be quite the norm, irrespective of which government seems to be in power. After the law being passed in 2008, it actually was implemented from 2009 onwards, which is often how laws get implemented, like how we adopted the Constitution on the 26th of November 1949, but we fully enforced the Constitution on the 26th of January 1950. So 2008 the law gets passed, 2009 is when the law comes into force, and barely 3 years later, in 2012, a 21-year-old law student at that time, Shreya Singhal, filed what is called a public interest litigation at the Supreme Court, challenging Section 66A to be violative of Article 19 among other provisions in Part 3. Now, the reason that this case was filed was very specific in nature. There was a trigger cause behind it. Around the time this case was filed, a couple of weeks or months earlier, the city of Bombay was completely shut down to commemorate the funeral of a senior Thakre leader. And I think 2 girls in Maharashtra had written a Facebook post critiquing in a rather satirical manner the shutting down of a city to commemorate a senior leader's funeral. And both of these girls in Maharashtra were charged with Section 66A. This caused massive outrage all across the country, and Shreya Singhal, of course, went to the Supreme Court with the PIL. This is 2012. Just 3 years later, 2015, the Supreme Court in the landmark judgment, Shreya Singhal versus Union of India, categorically said Section 66A is unconstitutional and should not be implemented. Now, in 2018, this is 3 years after the judgment, Abhinav Sekhri, who happens to be a lawyer of the Delhi High Court, and Apar Gupta, a leading public intellectual on civil liberties, had co-authored a research paper that said Section 66A and other legal zombies, where for the first time you were able to identify that Section 66A was still being used despite the Supreme Court categorically making it unconstitutional. In 2019, this was on the basis of a PIL by the Public Union of Civil Liberties, a leading civil society organization which also had assisted Shreya Singhal's case in 2015, went to the Supreme Court in 2019, and the Supreme Court issued fresh directions to the Chief Secretaries of all the states, the DGPs of all the states, and to all the courts in the country to be careful and not enforce Section 66A. This is 2019. Despite a Supreme Court direction, still cases were being filed till 2020 and of course much later. And PUCL approached the court again. And then in 2021, of course, this is now a matter of national debate. So this is the larger discussion. In fact, if you want me to narrate a very specific incident, I had taken a specific case out. There was an 18-year-old called Zakhir Ali Tyagi, who was from Muzaffarnagar, who had posted a comment on his Facebook questioning the Uttarakhand High Court's decision, and the Uttarakhand High Court had said that River Ganga is a living entity, and then he commented on that post saying, that post about the Uttarakhand High Court saying that if River Ganga is a living entity, then would criminal charges be initiated if someone drowns in River Ganga? Satirically, of course. Now, he was charged with Section 66A. This is much after the judgment, by the way. In 2017, a leading newspaper called The Telegraph had reported that Mr. Tyagi, the 18-year-old gentleman, spent about 42 days in jail because the police had registered a case under Section 66A. And of course, under other provisions as well. Now later, the provisions of 66A were then converted to provisions of Section 66, which is a legal technicality. But interestingly, when Mr. Tyagi was released from jail, he was also charged with sedition, which of course is a different controversy altogether. So there are enough instances of Section 66A being implemented. But you'd be very surprised to know that Section 66A is not the only law. Is not the only provision, so to speak. I'm reminded of the year 1983 in a judgment called Mithu versus State of Punjab, where the Supreme Court categorically declared Section 303 of the IPC as unconstitutional. Now, what is Section 303 of the IPC? Section 303 of the IPC said that if a person is convicted of life imprisonment, has been charged and is found guilty of an offence and was asked to, finish a sentence on life imprisonment, and if that person commits a murder, then that person must necessarily be given death penalty. A draconian section, honestly. The Supreme Court struck this section down in 1983. Now, interestingly, there was a gentleman called Shayu Prakash who was charged with this very section in 2012. and was sentenced to death penalty by the Rajasthan Sessions Court, criminal court in Rajasthan. Now, thankfully, all judgments which sentence death penalty must be confirmed by the High Court of that state. And luckily, the Rajasthan High Court got wind of it, figured out that you can't charge somebody with a section that has been declared unconstitutional by the Supreme Court, and this was just a matter of legality and luck. Otherwise, Mr. Shayo Prakash would have no longer remained with us. Similarly, in 2016, the Supreme Court had decriminalized Section 377 of the Indian Penal Code, which is very well known, where homosexuality has been decriminalized, which basically means it is perfectly legal for two consenting adults of the same gender to be physically intimate with each other. And in 2017 as well, the Supreme Court had pronounced a judgment on Section 497 Indian Penal Code and Section 198 Clause 2 of the CRPC. This was a very, very interesting piece of judgment. This was the case of Joseph Shine, if you would remember. And in the Joseph Shine versus Union of India case, the Supreme Court held that selectively punishing husbands for adultery is unfair and arbitrary. And Section 198 Clause 2, which was preventing women from initiating prosecution for this, was also unfair and arbitrary. So the Supreme Court has done this a fair bit, whether it is about adultery or saying how adultery was being charged to men and that was unfair, whether it's about decriminalizing homosexuality, or whether it's about removing a death penalty provision compulsory for life imprisonment convicts. So this is how the Supreme Court has sort of decriminalized or declared provisions of the law unconstitutional or invalid. Now comes a bigger question. After a Supreme Court judgment has been delivered, what happens? Now we know that there are three branches of government: the legislature, the executive, and the judiciary. Let's start with the legislature first. So ordinarily what happens is there's something called a parliamentary prerogative. Now the parliamentary prerogative is that once the Supreme Court has declared a provision unconstitutional, usually the Parliament must pass an enabling act to delete that provision from the official text of the legislation. The Parliament rarely does it because we all know how efficient the Parliament is. But this is symbolically a very important step to take. There is no compulsion for the Parliament to pass an enabling act to delete a provision, but the Parliament should. In fact, even today, if you go to India Code's website, and India Code is the official government laws database, you would find Section 303, 377, Section 66A of the IT Act, all written there as it is. So the official text of the law has not been changed. Then of course you have commercial publishers such as Universal or LexisNexis or any of these. What they usually do is they write a footnote with that provision saying declared unconstitutional under so and so judgment. But that's a very superficial way of going about it. I think it's one of those terms and conditions to the fancy sales that you get to if you buy two only if you spent 10k. That's the problem. So that's the legislative part of it, and I think that's something that does not happen, and it should. Second is how lazy the executive often gets. Now I'm sure all of you are aware of something called the Gazette. The Gazette is nothing, the official Gazette is nothing but it's like an official newspaper published by the central government and several state governments. Now, what is the Gazette supposed to do? the Gazette is supposed to inform government functionaries about developments in the government. New laws, new regulations, orders, schemes, etc., etc., etc. Now, here's the interesting part. I'll take your attention back to the Section 66A case. So when the PIL was filed by Shreya Singhal in 2012, the central government in 2013 had issued a central advisory in the Gazette and had asked and had directed states and had directed appropriate police authorities that don't register a case under Section 66A without the permission of senior police officers, which is basically IPS and above. Because the case was going on and the government did not want to invite more trouble. The interesting part is, after the judgment came out, there was no such mention in the Gazette whatsoever. Which basically means there is no standard procedure for developments on the judicial front that affect the government to be communicated in the Gazette. If you want to, you do. If you don't want to, you don't. Which I think is a major loophole and a flaw in the entire process. So there is no advisory, no notification given that Section 66A is no longer constitutional, don't use it whatsoever. Third, the judiciary itself. Now, a judgment has been delivered and the judgment has to be informed to the rest of the courts and the rest of the judges. I was looking up procedures of the Delhi High Court and I'd like to read out the provision as it is and I'd like to tell you. And I was finding out some details and here's the fun part. There is absolutely no provision of the Delhi High Court rules that say that Supreme Court judgments must be communicated to lower courts. None whatsoever. Similarly, there is no rule mandating the district court to issue circulars about Supreme Court judgments to various functionaries in a district. Right? Not at all. In fact, the only way people actually get to know about Supreme Court cases, the judges and the legal fraternity, is first, some high courts publish what is called a yearly digest of cases, where the high courts mention Supreme Court cases that have happened over a year. And second is commercial publication houses who keep publishing important, say, quarterly or biannually digests. But there is no official communication strategy whatsoever directing Supreme Court to High Court to District Court whatsoever. This is very interesting. In fact, if these are your problems, then what should your solutions be? It's very simple. The short-term solution could be that the Supreme Court, taking suo motu cognizance of the matter, can immediately start issuing very specific directions and making sure it is getting implemented. But this is going to be answering judicial review with judicial review. A more long-lasting, a more sustainable, a more worthy and a more moral solution to this would be that we should have a procedure in place. A standard operating procedure that says if Supreme Court judgments have been delivered, they should be communicated to everybody who needs to know them. The police officers who are implementing it, the administrative officers who are in charge for law and order, the high courts, the district courts, the lower courts, everybody should get to know this on a more formal and a more organized basis. And that's the key takeaway. That one of the world's most complex judicial systems does not have a formal communication strategy. And that is why, ladies and gentlemen, truth is stranger than fiction. Thank you.